Good afternoon. My name is Greg Lawrence, as you said, Chair White. Commissioner Stein, Commissioner Pivovar. I'm here with my co-counsel, Hannah Kahn. You can't see her, I'm sorry. Hannah, move out a little bit.
We see you.
And my client, Jonathan Feldman. Now, Jonathan Feldman's trades aren't the only trades at issue here. He's one of several clients who engage in this strategy. And the Reg Show case that you're here to decide presents complex and interesting questions and indeed credibility assessments of witnesses. The fraud case against Mr. Feldman, however, presents no interesting questions. It's unjust and it's without merit, and that's for two primary reasons. First, Option Express, as Mr. Senderwich just told you, consulted with the SEC, and after that consultation, they told Mr. Feldman specifically that the SEC had looked at his trading strategy and approved it, and looked at Option Express's compliance with their delivery obligations and approved it. That's uncontested. Second, the initial decision adopts an unjust and radical definition of what delivery means for a customer. The customer is not relied upon delivery, a retail customer isn't relied upon delivery in most instances, including in this case. And it's uncontested Option Express assumed all the obligations for delivery here. Mr. Feldman's only obligation was under his contract with Option Express. And it's uncontested, and Judge Murray found that Mr. Feldman complied with every request made by Option Express, and that he was truthful and honest with everyone with whom he dealt. Everyone. That's uncontested. He needs to be treated completely separately from Option Express in this case, because the Option Express case really is about Reg Show. Mr. Feldman doesn't work for a broker-dealer. He doesn't have any securities license. He's not a compliance professional, to be sure. I don't say this to try to convince you that he's not intelligent. He's very intelligent. But he learned about Reg Show for the first time in the middle of this trading. He learned about how trades are affected and regulations show. This was in August of 2009, after the period that they're already charging him with fraud. And then later, a month later, he learns of an issue with Hazan, right? He's provided a copy of Hazan, and immediately he gives the astute observation that his trading is completely different than that was addressed in Hazan. He was entering open market trades on standard options to unknown counterparties, and he was complying with every delivery obligation of his broker-dealer. He was engaging no deception whatsoever, and in fact, he did not want to be assigned, because when he got assigned, that affected his strategy. 4 days after learning of Hazan and any potential issue with his trading and delivery obligations, he's given the express confirmation from Peter Bettini, the executive vice president of one of the largest trading firms in the country, in the world, that they had consulted with your staff and concluded that his trading strategy was appropriate and they were satisfying all their delivery obligations that resulted from it. 2 days after that, Mr. Feldman is told in the phone call the same information, so he gets reconfirmation. He believed them. He believed that the SEC had actually approved of his trading strategy and that Option Express was fully complying with his Reg Show obligation. Was that true? For this fraud case, it doesn't matter. It doesn't matter at all. They said it, they never took it back, and they confirmed to him over and over and over again after that they were taking all their delivery obligations and conforming them. Now, the initial decision says that, actually, and let me back up for a second. The initial decision almost doesn't even address the SEC approval. The initial decision and the division talk about how Mr. Feldman can't rely upon Option Express for two reasons. Number one, they're making money off his trading. Well, that's every situation for a broker. Number two, he's sophisticated himself. Well, that overstates it, and I've already addressed. He's not a compliance professional. He's just learning about the rules, and the rules are very sophisticated. The initial decision naively suggests that he should have called the SEC, and yet the SEC representative who testified said they would not have even taken his phone call. SIBO testified to the same thing. FINRA testified to the same thing. He couldn't get guidance if he wanted to. In any event, even if he fully understood Reg Show, he didn't have the tools and the visibility to actually determine whether Option Express was complying with it. Why? Because you need the books and records of the broker-dealer, and you need the CNS position. He had neither. Ultimately, he did consult with an expert in Reg Show, and that's Dr. Eric Seary. Dr. Seary was the director of trading markets, as the chair and commissioners know, was the director of trading and markets for the commission. And he confirmed that Mr. Feldman's trading would not have caused Option Express to violate Reg Show. I repeat, would not have. And he was the director of trading markets when Rule 204 was passed, when Rule 10b-21 was passed. Dr. Siri's analysis was even more enlightening, though. He looked at all the trading that Mr. Feldman engaged in. And so he looked at it in toto, and I've got the screen up on the slide up on the screen here. And in fact, it shows that the division and the initial decision are relying on selective data to show that there was a high frequency of assignment of his calls on the same day. In fact, there wasn't. It was variable. And so the initial decision actually takes off just little slips and slaps of the actual trading strategy. Only about 30% of it is charged. And the initial decision, and please don't make the same mistake, the initial decision says, well, that's just trading that he engaged in the strategies without using buy rights. That's not true. As Dr. Siri's slide shows, the white dots there, the white dots show actual buy rights being used. And by the way, all those positions, all of them weren't charged. There's also a bar graph that shows that the same-day assignments were actually less frequent. As a final point, the disgorgement figure used was unacceptable and violated his due process rights. Rule 600A requires the commission to find each violation and calculate disgorgement. She threw up her hands and said, I'm not going to comply with 600A because there's too much trading here, and I'm just going to use rough estimates based on faulty data. Dodd-Frank gave this commission broad power over lay people. Lay people deserve the same due process and justice that they would get in a federal court, especially when you're alleging fraud against them. Here, this hasn't happened yet. And it hasn't happened because the division hasn't responded to, and the initial decision doesn't address very fundamental arguments that we've made. They just ignore them when we talk about in the reply brief. But today, let me give the division one last chance. Under these facts and circumstances, how can Mr. Feldman be held to be making a misrepresentation when the Commission's own adopting release for 10b-21 says that a customer would not be making a representation if they're relying on their broker for compliance? Thank you. Thank you. Well, the division had their last chance, and they still didn't give you an answer. And that is 10b-21 adopting release said a customer doesn't make a representation. And that's expressly what this case is based on, the initial decision and the entire case of the division. Instead, they cite Wharf Holdings as giving an example of why this is fraud. Because when you sell an option, you have to live up to it. And if you sell an option without the intent to deliver, then that's fraud. Well, Wharf Holdings didn't have the CNS system in place, which is exceedingly complex, but it makes your broker the one who's going to do all the delivery requirements after the option is sold. Wharf Holding is a simplistic analysis. Counterparties to a trade, face-to-face, physical delivery of whatever it is. It doesn't deal with what Reg Show deals with. It doesn't deal with the reality of this case and what the Commission has put in place and sanctioned with regards to how trades are settled. This is a Reg Show case, not a fraud case. Interesting questions. But here also I see people conflating the red flags potentially that were going on in Option Express with red flags that would be for Feldman, just like they're conflating delivery obligations. Mr. Feldman was told that the SEC approved of the trading strategy and approved of the settlement of those trades. He was told nothing else. And so everything else after that, until he's presented with something that would be sufficient to raise an issue, is meaningless for him, for the fraud case. This is a fraud case against a layperson who's relying on their broker-dealer, and reasonably so. We believe they were complying. Dr. Siri did say that his trading would not have caused it. So if he was the only trader at Option Express, then the trading would not create a CNS, would not create a violation of Reg Show. And to your point, Commissioner Stein, he was aware of CNS fails because they told him. It started at about the time with Hazan. He started learning about why they were requiring him to take certain actions because they had to comply with Reg Show. So they started implementing new restrictions on his trading, right? They were telling him we have to do things differently because certain things are happening. The other brokers didn't tell Mr. Feldman that his trading was violating Reg Show. That's just false. That's not the testimony. There are capital requirements that are caused because of his trading such high volume and the massive positions that he was putting up. We don't dispute that. He was perfectly comfortable with it. He was taking the risk with those positions, but the brokers were incurring charges. Option Express, however, did not pass along hard-to-borrow fees. Either did E-Trade, either did Pinson, either did TD Ameritrade. That's how he made money. He made money off of doing his trades with brokers who didn't charge hard-to-borrow fees, because a lot of times he actually just sold the security short for a hard-to-borrow stock, and they didn't charge him the hard-to-borrow fee, hard-to-charge fee. In any event, I'm sorry, Commissioner. So he made money legitimately at all times. Certainly in his mind, he had identified an arbitrage opportunity. He deserves justice here for these fraud charges. He's a layperson who is relying on his brokers reasonably. Thank you very much.